Now let us start with the remaining part of the presentation, or the second part of my presentation. And here I would like to begin with what could be the appropriate methodology for teaching of international humanitarian law. Of course, it depends on the concerned teacher which methodology he or she prefers, but it is possible to think of certain general methods like interactive lectures, group discussion, seminar presentation, like asking students to prepare on certain topics and make a presentation in the class, ask at the same time other students to raise questions, and then the teacher can summarize and complement what the students have said. So there are various ways in which a particular topic can be tackled. Then it is very useful to use case method for teaching international humanitarian law. I have followed this method in many places and I find it extremely useful. Now, one thing I would like to make clear at this stage is when we, in the field of law, when we talk about case method, in most cases, most situations, people think of a case decided by a judicial authority. That is not the case in the field of international humanitarian law. When we say case method in humanitarian law, we are essentially talking about study of a recent or ongoing armed conflict. It may not have gone to the judicial authority, or there are no judicial proceedings which have taken place regarding what has happened during these conflicts, but studying a given conflict, past conflict or an ongoing conflict, and looking at what happened to IHL norms during those conflicts, or if it's an ongoing conflict like Syria, take the case of Syria, which has been going on for more than 10 years. What is happening to humanitarian law norms? You can ask your students to prepare themselves on these types of cases or these types of situations. And then they may talk about attacks on civilians, detention of people, using of chemical weapons, for example, or using prohibited methods of warfare, and so on. So there are various situations which involve applicability of humanitarian law when we talk about an ongoing conflict. And hence, such a situation offers a best example to the students. It makes their study more interesting because they are dealing with a live situation, a situation which is happening, which is evolving, which is unfolding on day-to-day basis. So this way a teacher can highlight norms regarding protection of civilians, protection of the wounded and sick, protection of prisoners of war, and so on. So study of a conflict is very useful. Sometimes it is possible for the teacher to create a fictitious scenario followed by a set of questions, because teachers can combine facts from different conflicts and prepare a fictitious scenario like a moot competitions case study or problem, where a fictitious case is developed for the purposes of a moot competition. So something similar can be done on a smaller scale for the class, for the discussion in a given situation. Say, for example, you are dealing with people who are detained in a non-international armed conflict, how they are treated, what kind of food is given, or whether they are denied any basic freedoms, whether they are being tortured, etc. So all these factors can be brought in, and a kind of fictitious scenario can be developed, and students may be posed a number of questions at the end of the scenario after explaining the scenario, or after giving some statement of facts, written facts to the students to prepare on. Then moot competitions and role plays are also possible in the field of humanitarian law. Moot competitions are always a useful tool for making students to prepare. Of course, in a moot competition, we give them a case study, we ask them to prepare, we ask them to present their cases, one side versus the other side, etc. So that also helps them to understand certain norms and principles of humanitarian law. Role plays, yes, certain things can be taught by using role play. For example, if you imagine a kind of meeting between a humanitarian organization in the Ministry of Foreign Affairs. So somebody on behalf of a humanitarian organization has gone to see the Minister of Foreign Affairs, and he or she wants to explain what's happening in a given conflict in their country and what the organization would like to do. So these types of scenarios can make discussion more lively, and then also to give a glimpse into practical realities, how you have to negotiate, how you have to deal with higher authorities, how you have to put forward a point where you want to bring in a violation of rule of international humanitarian law. So role plays are also useful, and there are many teaching aids that are available today, like manuals, casebooks, slideshows, videos, and many are available on the website of International Committee of the Red Cross that is promoting teaching of international humanitarian law. There are sometimes online modules as well. Some organizations have developed online modules for teaching of certain topics, subtopics of international humanitarian law. Now, another aspect of teaching humanitarian law is to highlight contemporary issues and challenges. These can be included at the appropriate places, integrated into our presentation. There need not be a separate discussion on contemporary issues and challenges, because these need to be integrated in our entire presentation. For example, let me give you a very simple example. If we are dealing with, say, non-international armed conflicts, the topic for our discussion is non-international armed conflicts, we need to tell students about new forms of non-international armed conflicts and new questions that have arisen in connection with, say, for example, fight against terrorism, which has become a kind of common phenomenon during the last 20 years, especially after 9/11 attacks and what we have been seeing at that time in 2001 in Afghanistan, and thereafter in other parts of the world as a part of the so-called war on terror, what was done. And so in many situations, in many students or participants of a presentation in a seminar or a workshop, they ask questions. What about war on terror? Is it an armed conflict? Is it an international armed conflict? Is it a non-international armed conflict? Now these issues must be integrated when we are dealing with these types of topics. So today we also talk about transnational non-international armed conflict, which are a modern form of non-international armed conflict, like when an armed group, as you know very well, a non-international armed conflict is a conflict between an armed group on one hand and the state on the other hand, in a very straightforward typical scenario. But in today's context, what happens is this armed group, it may be located in the country with which it is fighting or even outside that country, and from there it is pursuing its objectives. Or even one step going ahead, an armed group may be located in 4 or 5 other countries and then fighting with only one country. And this is an example given about the conflict between Al-Qaeda and United States of America. And it is said that Al-Qaeda has bases in a number of countries, and from there it is pursuing a kind of non-international armed conflict with United States of America. So imagine a complex scenario like this conflict between US and Al-Qaeda, which is outside the US essentially. It may have some presence in US, we don't know, and we also don't know in which other countries Al-Qaeda is located, because it's a very secret organization and it is pursuing its activities in a very different way, by perpetrating attacks, by preparing attacks in different ways, not necessarily launching attacks, but even fundraising. Take the example of fundraising for launching an attack. That is also a part of, preparation for an armed conflict. So it is important for students to know these developments, and these should be integrated at appropriate places throughout our presentation. Another example of the same thing I would like to give you about, when we are talking about combatant status, we should also talk about the staff of the status of the staff of private military security companies. As you know very well, during last 10 to 20 years, number of countries are relying on private military security companies to delegate some of the traditional functions of regular armed forces. And hence it has raised a number of questions. What is their status? Are they lawful combatants? Are they mercenaries? Are they unprivileged combatants? Whether, if they are captured, whether they are entitled to prisoner of war status or not. Now these are the contemporary issues and some of the new challenges that are arising in the field of humanitarian law, and these must be highlighted, these must be integrated at appropriate places. Then it is important to link new challenges to development of humanitarian law, because whenever in any field you have new challenges, you need to develop the law to deal with the new challenge, the new situation, and sometimes the law responds in a positive way. For example, take the case of cyber warfare. Now there is a lot of discussion because cyber technology can be used for armed conflict. Cyber attacks can cause a lot of loss in adversary's territory, and hence it has the potential to operate as a weapon of warfare. But then it has its own peculiarities and complexities, and hence the normal rules applicable to traditional warfare may not be relevant or may not be adequate to deal with challenges posed by cyber warfare, or which they might pose in times to come. And hence it is important for the international community to prepare, to develop new norms to deal with these situations. Already some discussion is happening on this front. There is a manual prepared by an organization in Europe. It's associated with NATO. There is a NATO Center of Excellence on Cyber Warfare in Estonia at Tallinn, the capital city of Estonia, and there is what we call as Tallinn Manual, which is a collection of norms regarding applicability of international law to cyber warfare. So these are the types of examples. They highlight the fact that how it is important to develop the new law or develop new norms of humanitarian law to deal with new challenges. Another example could be autonomous weapons or robotic weapons. There is a lot of debate and discussion going on about ensuring respect to humanitarian law if robotic weapons are developed and deployed in certain real conflict situations. There are certain proposals that are emerging within the conference on disarmament, and some discussion is going on. There is, as I told you about private military security companies, there is a lot of debate and discussion happening, and there is a document called as Montreux document, which talks about best practices of dealing with private military security companies. So it is important to highlight that new developments in the field of humanitarian law are closely associated with new challenges, or to put it in other words, when the international community is confronted with new challenges, it needs to think of developing new rules of international humanitarian law. Then again, new developments in the field of humanitarian law are also closely linked with political, economic, social realities of the contemporary world. Because the law cannot be detached from these realities. It doesn't operate in isolation. It operates in a specific environment which has certain dimensions like political dimensions, economic dimensions, social dimensions, and so on. Take the case of nuclear weapons. The issue of nuclear weapons is highly politicized, and it has many security implications, and the states which are nuclear powers are very reluctant to accept restrictions on their nuclear capabilities. This is highly politicized because they are concerned about their security, their sovereignty, and they are concerned about threats from their adversaries. So nuclear weapons, of course, they are very closely connected with political factors. Then we have, take the example of Arms Trade Treaty. There is an Arms Trade Treaty adopted in 2013 which places restrictions on sale of arms or trade in arms, and to ensure that arms do not reach irresponsible hands where there are violations of IHL or human rights happening. Now this is very closely associated with economic interests of states because it can impose restrictions on international trade in arms, and the treaty aims at curtailing arms availability to those parties to a conflict that are violating the rules of this law. It is equally important to highlight the fact that the new developments are, they make humanitarian law a dynamic law, but the dynamism of humanitarian law is slow because of political realities. So it will be good for a teacher to impress upon a student that developments in this law are required. This law needs to be dynamic, but there are restrictions because of the political factors, and the development of this law is going to be invariably slow. Then often developments in other disciplines also impact development of humanitarian law. Let me give you some example. History. History can impact global developments. For example, major wars. If you look at the way humanitarian law has developed, this has happened in view of experiences of major wars. Take the case of First World War, 1914 until 1919. During this war, poison gas was widely used, and as a response in 1925, Geneva Gas Protocol was adopted to ban use of poison gas as a weapon of warfare. Then take the example of Second World War, 1938-39 until 1945. The Geneva Conventions of 1949 were adopted in response to Second World War to see that the law which was not adequate, humanitarian law which was not adequate at the time of Second World War, was further strengthened by, and it was made a bit comprehensive by adoption of 1949 Geneva Conventions. So we have many examples of major wars impacting subsequent developments. Another example I would like to give you is that of Vietnam War, during which there was lot of discussion on modification of environment for hostile military purposes by United States, such as causing artificial rains and so on, with a view to trap the enemy and launch attacks and so on. Chemicals such as Agent Orange were used to cause artificial rain, which caused damage to the quality. I mean, it impacted on the health of people who were exposed to these chemicals, and they also these chemicals also rendered certain land useless for agricultural cultivation after the war was over. And then in response, in 1977, Environmental Modification Technique Convention was adopted to prohibit deliberate manipulation or modification of natural environment for hostile military purposes. So we learn from history, and historical developments also impact development in the field of humanitarian law. Then political realities, major changes on political front also have impact. If you look at the end of Cold War, early 1990s, just after the end of Cold War, it was possible to create international war crime tribunals for former Yugoslavia, for Rwanda. These two major tribunals were created in the years 1993 and 1994. That was possible because East and West could collaborate and agree on creation of these tribunals. These were of course created by UN Security Council, but nevertheless it underlines the understanding between major powers of the state. For example, the newly established Russian Federation did not object to creation of a special tribunal for former Yugoslavia. That is how it became functional, and it could address some of the violations committed during the conflict in former Yugoslavia. Then developments in the field of trade and commerce, they also have impact. For example, maritime warfare and merchant shipping are very closely associated, because protection of merchant shipping is important in times of maritime warfare. The emergence of private military security companies, arms trade, etc., these are also related to trade and commerce. So these developments, whenever these happen, I mean, regarding trade, arms trade, already we have a treaty, but we don't have as yet on private military security companies. But that would be because of developments in these other fields which are extraneous to humanitarian law. Then developments in the field of science and technology also impact developments in the field of humanitarian law, such as blinding laser protocol, which was adopted in response to development of laser technology, which could have the potential of blinding people, and some states that were seriously conducting research to develop these types of weapons. Then artificial intelligence, robotic weapons, cyber warfare, these are developments in technology essentially, but they have implications for humanitarian law. Then today we talk a lot about protection of natural environment. It has become a major global issue, and protection of natural environment even in times of armed conflict, like protection of cultural property in times of armed conflict, are issues of concern for the international community, and certain developments have taken place in that direction as well. Now I come to certain suggestions about questions which may come from students. Of course, as a good teacher, we leave no query unanswered. We try to deal with each and every query. And if we are not sure about a question that is posed, we can always admit that, and we can tell the students that we will come back. And as I said earlier, we can allow questions at any time or at the end, depending on the convenience of the teacher, but I would rather prefer allowing questions at any time in the course of our presentations. Then also, of course, when students pose questions, we need to ascertain whether their queries have been satisfied or not, and whether they have any supplementary questions. That is the way we have to leave no query unanswered. Now I would like to offer a few concluding remarks about both the presentations, the first and second part, that I have touched upon a number of key issues concerning teaching of international humanitarian law. Of course, we have already noted that humanitarian law is a dynamic law. It keeps evolving to address new challenges. It has assumed considerable importance in today's world on account of proliferation of conflicts in different parts of the globe. And on day-to-day basis, humanitarian law questions are arising at the global or regional or national level, and therefore it is important that this law is widely known by people, and there are people who are experts in this field of law. Then of course we have noted the fact that the regime of humanitarian law, though it is weak, it serves a very important humanitarian purpose, and it is necessary that it is further strengthened. It operates within the general framework of public international law, and naturally whatever weaknesses are there in public international law, they also affect the field of international humanitarian law. It has of course links with other key areas like human rights law, law relating to use of force, refugee law, migration law, international criminal law, and so on. Expertise in the field of humanitarian law is required at the national as well as international levels, and hence some students, if they want to specialize in this field, they will always have some scope. Many human rights organizations, NGOs, they operate in conflict affected areas, and they need experts in humanitarian law to advise them or to deal with some of their projects. Finally, I would like to say certain things which you already know, like teaching is of course aimed at conveying knowledge, and teacher needs to ensure whether the objective of teaching is achieved or not, and to that end we must try to understand the level of knowledge of students of the given topic, and then raise that level of knowledge through our teaching. And let the students know that they can come back to you at any time. They feel reassured that if they have some queries at a later point of time, there will be somebody to respond to their queries. Because ultimately, and I would like to end on this, that satisfaction of an average student is paramount for a good teacher. Because we are not talking about highly intelligent and very clever and smart students, but we should aim at an average students. And therefore, satisfying an average student is important in my view. So with this, I would like to close my second presentation, and I hope I have given you some useful tips for teaching of international humanitarian law. Thank you very much.